Hi, I'm Abby. I'm a legal advocate here at St. Paul and Ramsey County Domestic Abuse Intervention Project down in St. Paul, Minnesota. I've been a legal advocate at St. Paul Intervention for about 5.5 years now, since 2010. And I've done a lot of legal advocacy both on the criminal side and the civil legal side, which order for protections are in. So some of the things that I'm going to be talking about are what is my role during the order for protection process and working with victims of domestic violence? What are some challenges that we face when working with victims and being in that supportive role, while also following what the court procedures are at the same time, because we're going to be there for the victim, making sure that she feels comfortable, safe, prepared during that process. So one of the first things that determining when I'm working with a victim of domestic violence is whether or not an order for protection is appropriate or not for safety planning. Things to talk about are, is it even safe for her to be sharing her story or what the allegations are? Because once she writes it down and he's served with it, he's able to read the whole thing. So discussing the pros and cons of that, discussing whether it's going to be safe for her to be the one to do that, because there's other avenues to go as well, such as having her landlord trespass and have the blame basically be on the property management landlord and not be on her to keep him away from that distance. Also, it might be something that's more appropriate for custody court, a divorce hearing, harassment restraining order. So those are things that you want to be talking with the victims beforehand, before even filing that. Some things to do through the filing process, because it's a very detailed document, is new things will come up about parenting time and custody, housing. So that's a good time to talk about housing law and what her housing rights are, her employment and what her rights are as a victim of domestic violence with the employment. Those are a myriad of things, as well as how the order for protection can affect those other aspects of her life. Such as going to the court hearings and so on. Preparing for a court hearing can be very extensive, because there's very specific things that can be admitted into a court of law through evidence, how to present that evidence. An example of that is evidence, anything that's presented to court and as evidence is held for 120 days. So if she has text messages that are threatening, emails, she has to figure out how to get them into paper form to present to the judge. She can't just show it on her phone, because otherwise it'll be held for 120 days. And I know I can't live without my phone for 120 days. So those are things that you have to talk about. And I can find, sometimes that's one of the most challenging parts. There's a good idea to create like an evidence checklist to make sure that they are prepared for that. At the hearing, that can be a very challenging piece to be in, because we're not speaking on behalf of the victim. You will be in a position where you will know what the law is. You will think would be a good point to interject in, but because we're not attorneys, we can't legally give legal advice. We're there to provide support and guidance. So it's important to talk about those things before the proceeding happens. But typically what I will do is I will bring a notebook write notes back and forth with my client, the victim of domestic violence. They can ask to have a moment with us while we're in that courtroom to discuss options, or if she's nervous and needs a break. Those are all okay things to happen. And one of the challenging things of being in that courtroom too is you may think of questions, or like she really needs to bring up this topic, and even though you've gone over it a bunch of times, her adrenaline is going, she sees her abuser right there, and she may not remember to bring it up. And that can be a very challenging position for us to be in as advocates. But it's important for us to remember that we are there to support her. She is the expert in her life. She knows what's going to be safest for her, and we're there to help shed light on what her options are and address the concerns she has and support her in whatever decision she makes with that, and be there for her down the line no matter what with that. After the hearing, obviously, if she gets the order granted, it can be a good time talking about safety planning, who to give the order to, how to exercise it. But typically, it's really hard when an order for protection is not granted. And it can be very hard to do safety planning in that moment, but addressing the specific concerns that she has for immediately leaving there, having a follow-up plan to talk with her later on. Maybe that day is not a good day to figure out long-term safety planning, and always doing that follow-up with her and figuring out other avenues that may be able to help besides that order. I hope that you found this helpful. It's always important to remember that we are there to support her. She is the expert in her life, just like we are all experts in our own lives. And to always have support within our own sisterhood too when supporting advocates. Thank you so much.